So we have some important news coming out of the Supreme Court in their next big firearms and ATF overreach case. So let's talk about what just happened. Also want to thank the sponsor of this video, which is my Patriot Supply. I'm not a doomsday prepper by any means, but like many of you, I prepare for the worst case scenarios. That includes stocking up firearms, ammo, water, and also emergency food. One of the companies that I've used to buy emergency food even before they became a sponsor of this channel was in fact my Patriot Supply. Their kits offer about 2,000 calories every day, plus a 25-year shelf life, storage life, so you don't have to worry about that food. And if you're just getting started with emergency food and purchasing this type of item, I'd recommend the 3-month emergency food kits. It's just enough, to actually dip your toes into this type of, preparing. It's one of their best sellers, and it can actually help you decide if you want to go even further. So if you're interested, you can order and you can go to the website preparewitharmscholar.com. So again, really excited about this sponsor, a really cool company. They have the same values as us. And if you guys are interested, again, check out those links. Now, as I mentioned in the intro, we need to talk about some important news coming out of the Supreme Court in the next big firearms case, and a case that again deals with ATF overreach. The Supreme Court recently granted review to the ATF's frames and receivers rule in a case called Vanderstock versus Garland. The case is now set to be heard and decided by the Supreme Court during the court's next term. And even more important now is this case and the impact that a new Supreme Court decision will have on this very issue as well, because the Supreme Court recently ruled in a 6-3 decision in the Cargill bump stock case. The Supreme Court recently struck down the ATF's bump stock ban, and now the ATF's frames and receivers rule faces the same fate. But the ATF is desperately fighting back and is arguing that their 80% rule, that their unfinished frames and receivers rule, is in fact valid. The ATF also attempts to avoid that 6-3 Cargill decision from impacting this case, and they simply tried to ignore it also in this brief, which is very interesting. Now, to understand what is at stake in this case and why the Supreme Court's hands were forced to take this case, we have to talk about what happened prior in this lawsuit. Originally in this case, the original plaintiffs, FPC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule against unfinished frames and receivers. Now, on review, a district court judge, Judge Reed O'Connor, granted a limited preliminary injunction against the ATF, which at that time prevented the ATF from enforcing this rule against Tactical Machining and their customers. Now, looking at the ATF's rule on frames and receivers, Judge O'Connor found that the plain text of the statute and that Congress also did not grant the ATF authority to regulate these types of items under these statutory terms. Now, after that first preliminary injunction, there were other groups and other companies like Blackhawk Manufacturing Group, also known as 80% Arms, and others who intervened as plaintiffs and then got similar preliminary injunctions. Then you also saw a bunch of other lawsuits that were filed by different organizations and other groups that piggybacked off of what happened in Vanderstock and got similar preliminary injunctions. Now, after the preliminary injunction stage, the plaintiffs in the Vanderstock case sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment in favor of the plaintiffs and struck down the frames and receivers rule entirely nationwide. So it was a nationwide vacatur of the frames and receivers rule. Of course, the ATF was not going to let that law stick, so they appealed up to the Fifth Circuit and at the same time sought a stay of that nationwide vacatur. Now, the Fifth Circuit denied that stay, and then that led the ATF for the first time to go up to the Supreme Court on an emergency basis. And on the first emergency review, the court in fact did side with the ATF, and they granted a stay of that nationwide vacatur. In the 5-4 stay, Justice Barrett and Roberts were the one who actually joined the liberals to decide in the ATF's favor. But again, that was just simply a granting of a stay. Now, after the Supreme Court issued that 5-4 emergency stay in this case, there were some of the plaintiffs, like 80% Arms, who went back down to the lower court judge, Judge O'Connor, and sought an emergency motion for a new preliminary injunction. Simply what they wanted was the fact that since the nationwide vacatur of Judge O'Connor was, kind of struck down, was put on hold by the Supreme Court, what they wanted was Judge O'Connor to issue a new preliminary injunction that simply maintained the status quo and put back in place the protections that existed prior for certain organizations and certain companies and their customers. And on review, Judge O'Connor agreed with those plaintiffs and put back in place those limited preliminary injunctions. But again, the ATF did not like that. So they appealed that once again up to the Fifth Circuit, And the Fifth Circuit denied that, said that Judge O'Connor could in fact grant that type of limited relief, that he was not directly defying what the Supreme Court said in their new 5-4 emergency order. But the ATF disagreed again and then went crying up to Supreme Court for the second time. Now, interestingly, once again, when they went up to Supreme Court, the Supreme Court again sided with the ATF and said that no, this even limited preliminary injunction should be struck down, and so it was struck down. Essentially, where that left this case is that the case and the review of the motion for summary judgment and the granting of that moved forward at the Fifth Circuit level, moved towards a final merits decision by the Fifth Circuit. But any decision that was going to be issued by the Fifth Circuit or really any other lower court judge would be halted because the Supreme Court said that no real relief could be granted in this case. Now, ultimately, on review, when the Fifth Circuit reviewed the merits of this case, again, they sided with our side and struck down the ATF's rule. That decision of the Fifth Circuit and the three-judge panel agreed with the lower court judge, Judge O'Connor, that the rule was in fact invalid. However, the Fifth Circuit panel stated that they believed an outright vacatur of the rule was not proper. It shouldn't have been issued, and maybe it should have been a little bit more limited in relief. And that really could be partially because of the Supreme Court stepping in early and stopping some of the, broad-reaching implications, because we've seen other nationwide vacatures of rules pass. The Supreme Court recently just reviewed one of those nationwide vacatures when it came to the Cargill issue. So this is also something that's going to be reviewed by the Supreme Court, whether or not the scope of relief was proper or not. And now that's led us to where we are here, where the ATF had a hard decision. Now, the ATF did decide to file a writ of cert to the Supreme Court, so it was the government themselves, the ATF, asking for Supreme Court review. And the Supreme Court did, in fact, grant review to this case. Usually when it's the government who is the one filing the petition seeking Supreme Court review, the Supreme Court will, in fact, grant review, and that's what's happened. And as I mentioned, the Supreme Court granted review to this case, and the ATF here has just filed their new brief in this lawsuit. And in this new brief, they argue that the regulated weapons parts kits fall within the plain text of the GCA, and therefore the ATF's new rule is not an overreach. They state that the rule's discussion of covered weapon parts kits underscores that those kits fall squarely within the Act's definition of firearm. As ATF explained, many kits include all the parts and tools necessary for anyone with novice skills to assemble a functional weapon within a short period of time, sometimes less than 30 minutes. Such a kit undoubtedly can be converted into a functional firearm readily because it can be converted within fairly quick efficiency and a fair degree of ease. Now, the ATF here is still holding on to that old argument that the potential ease of completing an unfinished frame or receiver, of completing these 80%ers, makes the entire parts kits, all of these parts, actually fall within the statutory text of what is a firearm. Now, also, this is an important point that we have to cover. In this lawsuit and in this brief, the ATF is making a similar argument that we saw play out in the Cargill case. They are not arguing that there is an ambiguity in the statutory text, that there's ambiguity about what is a firearm. Instead, they are arguing that the statutory text in the GCA about the definition of what is a firearm, they argue that that is clear and express, and that under the clear and express definition of a firearm, these parts kits will be defined as a firearm, that they are firearms. Now, you may be asking yourself, how does the ATF address the recent 6-3 decision in the Cargill case that dealt with a similar issue? Well, the ATF here doesn't really talk about it. They don't really want to address it, and so they kind of tried to ignore it. That is their tactic here in the brief. In fact, the Cargill decision is only referenced one time in the entire brief, really two times, the citation at the beginning and then once in the actual body and argument section of the brief. So the ATF's best strategy here is to try to avoid Cargill, try to say Cargill is not a similar issue, does not apply here when it comes to the interpretation of what a firearm is, in the actions of the ATF in defining what a firearm is and regulating these parts kits. They tried to ignore Cargill altogether. So the ATF is trying desperately to save their frames and receivers rule, but after Cargill, the writing is kind of on the wall. I think the ATF knows that, and so their best shot right now is to try to avoid it, ignore it, but that's not going to work in their favor. They're going to have to address it, and they're going to get hammered on it, I would anticipate, when the plaintiffs file their reply brief. So again, important things to watch closely as this moves towards a hearing and decision during the Supreme Court's next term. So again, as we get more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.